Great. All right, good afternoon, folks. Before we begin, I would just like to ask the commission members if they would please consider adopting a motion to appoint me as the temporary non-voting acting chair for this particular meeting.
I'll make the motion.
Okay, that was Supervisor Schneiderman made the motion. Is there a second?
Second.
I'm sorry, who was the second?
Dorian Dell.
Dorian Dale. All in favor?
Aye.
Any opposed? Okay, the motion carries unanimously. Thank you.
Could I comment on the motion? I would want
Yes.
to do that, but obviously I'm supporting the motion. But I think at this point, I'm very disappointed that the governor hasn't appointed a representative. I think that was key when we did the meeting where we took straw votes on the standards last week. It was unfortunate that the governor did not have his representative there, and we were one vote short. So I just want to go on record as saying, I think the governor should appoint a representative to the Pine Barrens as soon as possible. And I regret the fact that there is no representative to vote on perhaps one of the more significant decisions that this Pine Barrens Commission is going to make. Thank you.
You're welcome. Thank you, Supervisor Romaine. I'd just like to note that we have a quorum, but I would just like to go through a roll call so we can have that for the record of this meeting. So representing Suffolk County,
Dorian Dale.
Dorian Dale, representing the town of Brookhaven.
Ed Romaine and Emily Pines.
Thank you. Representing town of Riverhead.
Dan McCormick, and I do want to advise you that Supervisor Aguiar will be joining us during this meeting. She's currently in the town board meeting addressing town matters at this time, but she will be coming in as soon as possible. Thank you.
Thank you. And representing the town of Southampton.
Supervisor Jay Schneiderman.
Thank you. Okay, I just have a brief statement to read in regard to the conduct of the meeting. Good afternoon. My name is John Pavasic, and I am Executive Director of the Central Pine Barrens Commission. I will be serving as the moderator for today's meeting. Before we begin the formal commission meeting, I would like to review a few guidelines and provide some pertinent information. This is the January 20th, 2021 regularly scheduled meeting of the Central Pine Barrens Commission. And as noted, for the record, a quorum is present and minutes will be taken. The notice of the meeting followed the open meetings law as amended by Executive Order 202.1 and is subsequently extended, which allows meetings to take place remotely. Today's commission meeting will begin with the reading of public comments and approval of the minutes, followed by regular commission business as detailed on the agenda until approximately 2:45 p.m. At that time, preparations for the Vincent Dell Esperanza public hearing will commence, with the public hearing beginning at 3 o'clock. The hearing will include a presentation on project updates and public comment period. After the public hearing has concluded, any remaining commission business will be addressed, including the reading of closing public comments. An executive session will be held at the end of the meeting to discuss legal matters, and it is anticipated that the commission will come back out of executive session into public session. Please ensure that you are clearly identified by your first and last name. If you are not, you can right-click on your name in the upper corner of the participant box and rename yourself, or send a chat to the commission with your name, and we will update your contact information. This is critically important to help ensure that the public hearing comment period goes smoothly and that we can clearly identify you during the public comment period. In regard to public participation, please note that members of the public may listen to and view the meeting. There are two opportunities to provide written public comment today. First is during the opening public comment section of the meeting. The second is at the end of the agenda during the second public comment period. Written comments that have been submitted via email will be recited during these public comment periods. Please note that the opening and closing public comment section is reserved for non-Vincent Dell Esperanza comments Comments on the project that is the subject of that public hearing must be reserved for the public hearing. And then if folks have written comments to make at the end at this point, they can send them to info@pb.state.ny.us before the end of the meeting. In regard to public hearing comments, members of the public who expressed interest in speaking at today's meeting will be welcome to provide comment in the order in which the email reservation was received. Each individual will be provided 5 minutes to provide comment. You will be informed during your comment period when you have 15 seconds remaining in order to finalize your comments. After all those who have pre-registered have commented, an inquiry will be made as to whether or not there are any additional members of the public who have not yet commented and who wish to comment. Please indicate your interest in commenting by clicking on the raising your hand icon in the Zoom chat participant window. You will be called on in alphabetical order. As the final component of the public hearing comment period, each person participating by phone who has not yet spoken will be asked if they would like to provide comment to ensure they also have the opportunity to speak. Unless providing comment during the public hearing, audio will be muted and video feeds disabled for the entirety of the commission meeting. The public may submit written comments via mail or email regarding the Vincent Dell Esperanza hearing for up to 10 business days following the close of the hearing. In regard to the commission members, voting on actions and resolutions will be done via roll call. All commission members are asked to clearly state their name when making a motion and clearly state their vote when their name is called. And in regard to recording and meeting minutes, the meeting is being recorded in the Zoom application and will be posted on the commission's website for viewing and listening after the meeting. The chat window is enabled for troubleshooting, and meeting minutes will also be prepared as is normally done. We will now go back to the formal beginning, the formal meeting. And I'd just like to ask folks to please stand for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Okay, we have the public comments portion. We've received 3 public comments at this point, 3 of which pertain to the Lewis Road Planned Residential Development. The first public comment is from Richard Amper of the Long Island Pine Barrens Society, and I will now recite it. I am appalled by last week's Pine Barrens Commission meeting's decline and the performance of the Pine Barrens Commission as of late. There has been no representation by the state, unresponsiveness to the need for a meeting of the Pine Barrens Advisory Committee, ignorance of the failure of the Lewis Road project to meet the standards and guidelines of the Pine Barrens Act and CLUP, no shared planning participation, and sorry participation on the part of commission representation members. Recent meetings are badly convened and unprofessional. Last week's meeting was unprofessional as John rubber stamped the impressions of Commission member Jay Schneiderman and unproductive contributions by Suffolk County and Riverhead. Only the most experienced commission member, Ed Romaine, was useful, but his contribution was largely ignored by the ineffectual commission members. There was no useful contribution on the part of staff, and my observation that the applicant's submission was not consistent with the provisions of the Pine Barrens Act and Plan was completely ignored. In addition, the expert input from environmentalists, scientists, local elected officials, and civic leaders from the past year was not even looked into nor discussed. The Pine Barrens Commission has declined in performance as never seen before. I will reach out to the founders of the Pine Barrens Act, advocates of Pine Barrens preservation, and others to try to restore the performance and purpose of the Pine Barrens Commission. The Pine Barrens Society has contributed immensely to the protection of the Pine Barrens, but has been increasingly disappointed by the service of commission members, especially in connection with those associated with the Lewis Road proposal. The Pine Barrens Commission has let us down in dramatic fashion. Shame on you. Dick Amper, Long Island Pine Barrens Society. The second set of comments is from Bob DeLuca of the group for the East End. His email forwarding says, to whom it may concern, attached, please find a copy of a letter from the group for the East End, which we wish to have read into the public comment record at the commission's meeting of January 20th, 2021. Thank you for your time and assistance in this matter. Best, Bob DeLuca. And the letter is dated January 20th, 2021. And it is addressed to me and says, "Dear Mr. Pavasic, on behalf of the group for the East End, a right to express our surprise and disappointment with last week's Pine Barrens Commission special meeting, a meeting specifically noticed as one to deliberate the Lewis Road application. Rational deliberation requires detailed, thoughtful, and careful consideration. Instead, and in stark contrast to extensive concerns raised by commission staff reports, hours of public comments, and hundreds of pages of written testimony presented by qualified experts, including authors and sponsors of the Pine Barrens Act, last week's meeting was defined more by the deliberation it lacked than the information it provided. For example, 1, despite the significance of the project, New York State failed to even send a voting member to the meeting, thus voluntarily disenfranchising the state's environmental interest in what should have been the most consequential meeting of this project's lengthy history to date. 2, despite extensive review by experienced commission staff, there was absolutely no presentation from or questions of staff planner Julie Hargrave. Adequate deliberation demands that commission members understand and openly resolve the numerous questions raised in staff reports, yet there was silence. 3, in the absence of any staff presentation or leadership, the Southampton Town Supervisor, a proponent of the project, and his town staff essentially assumed the role of commission staff and consistently steered the bulk of the discussion towards the most favorable outcome with scarcely a word from commission staff. The abdication of staff responsibility defeats the fundamental reason why the commission was created, which was to consider the consequences of Pine Barrens development outside of the narrower context of local interests, which had threatened the integrity of the Central Pine Barrens for decades prior to the Pine Barrens Protection Act. 4, despite extensive testimony presented by qualified experts regarding the project's lack of compliance with the State Environmental Quality Review Act, SECRA, the issue was never even raised. How the commission intends to designate itself as an involved agency for a type 1 action that has never been subjected to a coordinated review, never had a lead agency determination, never had a determination of significance, or ever completed an environmental impact statement remains unanswered and should have been fully discussed. Moreover, the commission should also carefully consider council's likely claim that its involved agency status is somehow still predicated on its historic involvement with a prior and long defeated change of zone application on the site of differing design, density, use criteria, and mitigation, and where the lead agency for that action no longer even has any discretionary permitting power over the subject application. The Lewis Road project still has no designated lead agency. 5, because the Lewis Road PRD action was never subjected to a complete SECRA review, the commission's review remains largely devoid of organized process and lacking in substantive information from virtually every other involved agency that still has some level of permitting authority over the project. As a result, this proposal remains a constantly moving target in terms of design, impact identification, impact mitigation, and project alternatives. Such fragmented review is exactly what SECRA was intended to prevent when it was passed more than 40 years ago. In conclusion, after more than a year of review, today the commission is poised to render a decision that is essentially a non-decision. This action only serves to relegate both the developer and public back into a regulatory free-for-all in which the final outcome of this project will now have to be debated before the Suffolk County Health Department, the Suffolk County Sewer Agency, the New York State Department of Environmental Conservation, and yes, even the Southampton Town Planning Board, which must now entertain the new map you may approve today. So we will just start all over again. If you can't see the implications of the failure of this process, I don't think you understand the legal implications of the Pine Barrens Protection Act or coordinated environmental review. If you can see the failure, it isn't too late to do something about it. Thank you for your consideration of these comments. Sincerely, Robert S. DeLuca, President, Group for the East End. And then the last set of comments is from Mr. Bill Kearns of East Quogue, New York. And in his forwarding email, he stated, "Good morning. Attached, please find my comments for today's meeting of the Pine Barrens Commission." Thank you. And his comments read, I must begin by acknowledging the tireless work of my colleague, Andrea Spilka. She brought passion and determination to her daily involvement in preserving that which we have in Long Island. She did it with a smile, something that more often than not is difficult to do. I was dismayed at the outcome of last week's Pine Barrens Commission meeting for a number of reasons. Firstly, no representation by the DEC/New York State. Certainly an important participant of the process and perhaps the least political and unbiased was noticeably missing. I'm not sure that the commissioners, with the exception of Commissioner Romaine, see the forest for the trees relative to this project. I believe this project is in direct violation of the Pine Barrens Act. 4 authors of the act, including Assemblyman Thiel and Engelbright, along with State Controller DiNapoli and the Pine Barrens Society, have both appeared before you and written as to the fact that this project does not comply with the Pine Barrens Act. I'm not certain that the commission realizes the overall cumulative impact that developing this property will have. Dozens of homes in Calverton at the Grumman site with tainted drinking water, Gabreski Airport leaking PFOAs into Shinnecock Bay, nitrogen-loaded toxic drinking water in East Quogue are all symptomatic of years of government neglect and disregard for the environment and the future of the region. Commissioner Jay Schneiderman patronizingly addressed the future of the hognose snake and the whippoorwill in the Pine Barrens with feigned concern, yet offered no solution to their imminent demise. What about the pine snake, the corn snake, the black snake? Is he concerned about the ruby-throated hummingbird, the Baltimore oriole, the screech owl, and the great horned owl, whose very existence will be impacted by development in these woods? Why were we not privy to the expertise and research of the Pine Barrens Commission staff, yet had to listen to a Southampton town staffer who has not chimed in on this project since it was first introduced 10 years ago? Of utmost importance was the fact that this project was positively assessed on a conditional basis. As has been the case since this project was brought before the commission, it is still in flux and it is still not completed, despite repeated requests by the commission to complete it and assertion by the developer that it is complete. The Pine Barrens Commission certainly cannot vote on a project that has so many loose ends and requirements that still need to be met and proven, and as such must vote no. When will these stipulations be met, if ever? Will they be satisfied at 11:45 a.m. this morning? I hope not, as that would not grant the commission enough time to review. I respectfully ask that the Pine Barrens Commission look beyond the minutiae of this application and process and realize that their task is to protect the Pine Barrens for today's residents and future generations. I further believe that any approval of this project will end your credibility and usefulness as environmental stewards of the region, something I would rather not see. Sincerely, William R. Kearns, East Quogue, New York. So that concludes the public comments that we have received up until the beginning of the commission meeting.
John, I just want to point out to the commission members, there was a letter from the comptroller. John and I talked about this. This was shared several days ago with the commission members. I think it was also posted on the commission website. And that's the reason it hasn't been read into the record. The record's closed on this project. So if you would like, I can read it, or John can read it. I'm sure he has it handy as well. But I just want to make sure that everyone recognized that that letter did come to the commission and it was forwarded to the commission members maybe Monday or Tuesday for sure, yesterday.
John, correct me if I'm wrong, but Comptroller DiNapoli at the time, going way back, used to be an assemblyman and was one of the sponsors of the Pine Barrens Act. Is that correct?
Yes, sir.
We should give some weight to his comments. Thank you.
Okay, we are now on to item 1B, the minutes for December 16th for review and approval. Those draft minutes have been distributed to the commission members. Is there a motion for approval?
I'll move approval.
Riverhead, second.
I'm sorry, who is the second?
Riverhead.
Okay, thank you, Riverhead, Dan McCormick. So there's a motion and a second. All in favor?
Aye.
Aye.
Any opposed? Any abstentions? Motion carries unanimously. Thank you. All right, so the next items are two draft resolutions. The first concerns the draft resolution delegating specified authorities to individual possessing stipulated Central Pine Barrens Joint Planning and Policy Commission job titles, and to specifically to Judith Jacobson, Deputy Director. So this in lieu of the permanent executive director, this allows certain prior authorities that were previously granted to the executive director to be given to delegated to Ms. Jacobson and any future acting executive director and a deputy director. I'd also ask before the commission acts on this that if we could also insert in this draft resolution the term of interim executive director as well, just to include that term of art. So with that said, is there a motion to move the resolution?
Motion from Suffolk.
Okay, including that amendment?
Yes.
Thank you. Is there a second?
I'll second
Second by Southampton,
as amended.
as amended. Thank you. All in favor?
Aye.
Aye.
Any opposed? The motion carries unanimously. Thank you. And the second one is a similar one. This is an amendment to the existing resolution that authorized the creation of the Wildfire and Incident Management Academy that the commission established back in 1999. And what this amendment would do is previously, in a previous amendment, the commission had granted the executive director a position on the board of directors of the academy. And so this would also allow, in the absence of a permanent executive director, the acting executive director or deputy director to fulfill that role. And I would again ask if we can just include the term interim executive director as well here. So is there a motion for consideration of this resolution?
Motion Riverhead.
Motion Riverhead. Is there a second?
I'll second.
A second by Southampton, Supervisor Schneiderman. All in favor?
Aye.
Aye.
Any opposed? Abstentions? Motion carries unanimously. Thank you. Okay, the next item on the agenda, request from the town of Riverhead to reschedule 2 commission meeting dates in 2021, changing the February 17th meeting to February 24th and changing the May 19th meeting to May 26th. Is there a motion for approval?
Riverhead motion.
Okay, is there a second?
Second.
Second by town of Southampton. All in favor?
Aye.
Any opposed? Okay, the motion carries unanimously. Thank you. Okay, next item we have is the item 2A under Science and Stewardship, the Community Wildfire Protection Plan. Ms. Jacobson, Judy Jacobson.
You're muted, Judy.
Oh, there I go. Okay. So we are continuing to make progress on the Community Wildfire Protection Plan. We hope to have the homeowner's guide completed before May, but I actually wanted to take this moment to present this plaque to John Pavasek on behalf of the commission and the commission staff. It's award of merit and distinction presented to John W. Pavasek, Executive Director, Central Pine Barrens Joint Planning and Policy Commission, in recognition of his extraordinary leadership, dedication, and excellence in guiding the Central Pine Barrens Commission and its staff to effectively implement the Long Island Pine Barrens Protection Act and the Central Pine Barrens Comprehensive Land Use Plan to ensure the proper management, environmental protection, and stewardship of New York State's Central Pine Barrens for the enjoyment of all. I just want to thank John, and I'm sure everyone else on the commission and the staff, for all of his hard work and accomplishments over his tenure as executive director, and for his over 34 years serving in various positions that help to further protect the environment and conserve our natural resources. And I also wanted to mention that we still will be having the retirement party, a virtual retirement party next week on January 27th at 1 p.m. So I hope you can all join us then. Thank you, John, for everything.
Thank you, John.
Bravo,
Thank you,
bravo.
folks.
Thank you, John.
I'm very touched. Thank you, folks. I'm very touched. Thank you. I greatly appreciate that. That it is quite an honor. So thank you. Thank you so much. I'm glad we're doing this via Zoom, because you won't be able to see the tears in my eyes, but I greatly appreciate that. Thank you so much.
Great job.
John, it's been an honor working with you.
The same here. It's been an honor and a privilege for me to have served in this capacity. And thank you so much for your support and your faith in me over these last 10 and a half years. I truly will cherish that as I leave this position. So thank you again.
Congratulations.
Thank you.
Good job, John. I just want to point out to the commission that all of, or most of the staff has joined us on Zoom right now. And that's a reflection of John's hard work, his leadership, and the person that he is in making people feel important and understand the importance of the job they're doing and encouraging them to do the best they can. So John, thank you for all of the staff. I think it's quite remarkable that everyone was able to pop in, even Sean Ziegler, who's got pine trees in the background. So thank you for everyone for attending, and John, for your leadership and your work ethic, which is an example for all of us to follow. Thank you, John.
Thank you. Thank you so much. I really appreciate that. Thank you very much, folks. I'm really touched.
Thank you, John.
We're all going to tune into your retirement next week.
Thank you.
Hopefully you have something interesting planned for the next stage of life.
Yeah, because Ed wants to really know how a young guy like you could be retiring, right, Ed?
No, that's true. Yeah, I asked myself the same thing. No, I'm planning, planning to continue in some other capacity, some other, position or positions. So that's something I will be trying to figure out in the weeks and months ahead. But thank you again for this great honor.
All right, now do the commission's work, John. Let's go.
All right. Yep. Back to business. Thank you. All right. So without further ado, we have item 2B, the Comprehensive Prescribed Fire Management Plan. And here we have before the commission a number of action items to designate lead agency, adopt a secret determination, and make a decision on the plan itself. And I would like to ask Polly Wiegand to please make this presentation.
Good afternoon, commissioners. It's sorry, some background noise. So on behalf of the Science and Stewardship Division, I'm happy to present you with the final draft of the Central Pine Barrens Comprehensive Prescribed Fire Management Plans and the findings of our SECRA review for your consideration and approval. The division has been very diligent in working and developing and seeing this plan to completion for the last year. Albeit it's been in development for many, many years. We hope that today we will see this version to fruition with your approval. The Comprehensive Prescribed Fire Management Plan, the plan is very important as it provides the guidelines and strategies and the components for developing and implementing restoration management activities within the Pine Barrens. The plan is consistent with the Long Island Pine Barrens Protection Act and ECL Law 57, Section 123-3A, which pertains to the comprehensive land use plan that recognizes prescribed fire as necessary for sustaining the ecological communities and the flora and fauna that are supported by them. The plan further fulfills Chapter 11 of the Wildfire Task Force Fire Management Plan that was drafted in 1999. and a deliverable under our 2018 through 2023 New York State DEC prescribed fire contract. With that said, at the Commission's December 2020 meeting, the draft plan was put forth, and the Commission initiated the Type 1 coordinated review pursuant to the SECRA Review Act. So the DEC and Suffolk County, the two involved agencies under this action, had no objection to the Commission serving as the SECRA lead agency. Comprehensive and an environmental impact review and analysis of the plan was completely conducted, which included the preparation of parts 1, 2, and 3 of the long environmental assessment form. The environmental assessment form 3 evaluated the components of the environmental assessment part 2 and discussed and evaluated any moderate to large impacts identified within the EAF part 2 to determine whether or not there may have been or resulted in any significant adverse effects related to the environmental impacts. The EAF part 3 assessment determined that the plan would not cause any significant environmental impacts. And rather, I would like to point out that because the Central Pine Barrens is a fire-dependent ecosystem, which has a long history of fire suppression, it is revealing the signs of declining health. And by implementing this prescribed fire plan and prescribed fire management will actually help improve greatly the ecosystem, the services that it provides, and benefits to public health. So as a result of these findings, a negative declaration has been drafted for your consideration. And as accordingly, as indicated in the draft resolution that was put forth to you, in order to move forward, the Commission has a number of actions for your consideration as it pertains to finalizing the SECRA review and finalizing the plan. The first recommended action is for the Commission is to establish lead agency for the Type 1 coordinated review, especially as there's been no objections from involved agencies. The second action would be to adopt the negative declaration determination as it relates to the SECRA review process for the plan. And the third would be to then adopt the plan as drafted in its final form.
All right, so the Commission members have been presented with the updated version of the plan, which has incorporated comments received from both the involved agencies and other entities, and also from a result of
Come on in.
public outreach. And so there's a draft resolution to adopt a secret negative declaration. Well, first to declare lead agency following the close of the 30-day coordinated review period, adopt a secret negative declaration, and then finally to adopt the plan itself. So is there a motion?
Motion to adopt lead agency status
Okay. And the rest of the resolution?
and the rest of the resolutions.
Thank you. Okay, is there a second?
Second on both scores.
This is-
Second by
Dell.
Mr. Dale. Okay, all in favor?
Aye.
All right.
Any opposed? Okay, any abstentions? Motion carries unanimously. Thank you very much.
By the way, I'd just like to comment that the plan was exceedingly informative and diverting. I can only applaud. It was normally when one has 170 pages to read, it's a painful chore, but this was actually quite educational. So I can only say bravo once again.
Thank you. I wanted to, recognize Bob Pankow and Sean Ziegler, especially their expertise and knowledge in prescribed fire was absolutely integral to the development of the plan related to the prescribed fire activities that we are going to be moving forward.
Yes, I'd just like to add as well, I've seen these folks spend hundreds, if not thousands of hours over the course of the past year on this, led by Bob, who's just the magnificent individual who brought his years of experience and expertise to this, and then Sean as well, who helped support that effort and embellish this plan, and Polly really helped to oversee and move this ahead. So it was a wonderful team effort, and these folks really deserve quite a few plaudits for the work they've accomplished.
And you too, John. I know you put a lot into this as well. It's a very
Thank you.
detailed plan.
Thank you. All right, so now we have, thank you, folks. So now we have 2C Education and Outreach Report from Melissa Peratt.
Who will be unmuted in 1 minute.
I
You're now
got me.
unmuted.
I got me. Thank you.
Welcome,
So
Melissa.
I am excited to see you all. It's been a while. So during this pandemic, we have continued to adapt our needs as far as education and classroom activities. Luckily, I have been able, up to about a couple weeks ago, still do some in-class activities and lessons, but a lot of it has been done remotely. And we've accomplished a great way to achieve our results when it comes to educating about Long Island ecosystems Pine Barrens, as we've recorded sections of programming. The classrooms have viewed those recordings, and then we are in for a Q&A. So it's been, the teachers are enjoying it. So we're getting to a point where it's the new normal, and it is very positive. Barrens Bay Summer Camp. This is an area where I'm really hoping that we could do some in-person activities this summer. However, different they will be. Hopefully the visitor center at Wertheim will be open, and we will be able to continue our normal programming. Obviously, following CDC guidelines, new COVID guidelines, with social distancing, temperature checks, etc. If the VC is not open by the time of camp start, we are looking to do an adapted program, minimum hours, and a minimum campers. So we're in the process of developing that, working with Wertheim and of course water authorities, making sure that we're on track with COVID guidelines and any insurance issues that we may come across. Long Island Natural History Conference. We are moving forward again remotely. We'll be doing probably 3 conferences, once a month. They will be on a Friday, and they will take place for approximately 3 hours a day. The exact dates will be decided, and I can update on my next education update, but it'll continue to be a great program. And a day in the life, we have some new team members from BNL and Wertheim on board. So we're able to really deep dive into some curriculum development and really manage and bring all that data that we've had since 2014 into a workable, manageable program for teachers and students to be able to use in their classroom. Thank you.
All right, any questions for Melissa on her report from the commission? Okay, thank you, Melissa. We now have item 2D, the Science and Stewardship Division update from Polly Wiegand.
Hi there, me again. So because we're short on time with a lot in the commission report, and I just provided a well update on the comprehensive fire management plan, I would just ask if there's any comments reflective of my report or questions. All right.
All right, thank you, Polly.
Thank you, Polly.
Thank you, commission members. So now we're up to item 2E. This is a draft resolution to appoint the Protected Lands Council Chair and Vice Chair for calendar year 2021. Is there a motion to adopt?
I'll move the motion for the appointments for the chair and vice chair.
Okay, thank you. Is there a second?
I'll second.
Second by Supervisor Schneiderman. All in favor?
Aye.
Any opposed? Any abstentions? Motion carries unanimously. Thank you. Okay, the next item we have is a compliance and enforcement update from Tim Huss.
Tim has to unmute himself.
Can you hear me?
Yes.
Yep.
Okay. I apologize for that. Well, I voted the reports and I guess we are running short on time, but if you have any questions or, want to give me comments either now or offline on some of the cases that we've had, we did have a record number of cases this year. So, as you're aware, and you probably saw the press release that Tim Moats helped us do a couple of weeks ago. So that's typical of what we've been doing. But other than that, thank you for your support and your interest.
Okay, thank you very much, Tim. Are there any questions for Tim?
There I am.
There he is.
Yeah. Got a big job ahead. I think that 2021 is going to be even more active than 2020.
Yes. I like to think we're making progress, Ed. We're seeing a little less activity at our camera site. So, but we'll see what the springtime brings. But thanks.
Let me know if you need more cameras.
Oh, I appreciate that. Keep that in mind. Thank you very much.
Absolutely.
Thank you. All right, thanks, folks. Okay, the next item is item 3B, Land Use Division Report Update. Ms. Hargrave, Julie.
Thank you. Good afternoon. You have my report, so let me know if you have any questions, but just to remind you that you have a Kogel Brothers core hardship pending, today's hardship for Dell Esperanza that will need an extension at the end of that hearing, unless it can occur now because of the rescheduling of the February meeting. It's now 2 days after the deadline, so we will need an extension for that. And you have the other items that we've received inquiries about and other determinations that are pending. And we also plan to bring back to you the plan amendments that you may remember 4 years ago, you adopted a scoping document for a draft environmental impact statement. And we have a draft version to share with you and get your feedback on, and then go through the public process to consider those for adoption. So that's all I have. Thank you.
Thank you.
Okay, thank you, Julie. Any questions for Julie from the commission members? Okay, hearing none. We'll move on to 3C, Credit Program Update from Mr. Taverdi. Jerry.
Good afternoon, everyone. So you should have received the report for the main activities that took place in the credit program for 2020. Not sure if you have a lot of time, but if you have any questions, I can outline the main.
Thank you. Thanks, Jerry. Does any of the commission members have any questions for Jerry? Okay, thank you. Hearing none. Thank you, Jerry. We'll move on to the land use activity portion of the agenda. And the first item is under the core preservation area, 3A, PSCG, Long Island, construction of a 150-foot monopole at Riverhead Substation, Riverside, town of Southampton. Ms. Hargrave.
Thank you. There's a draft resolution in the package. This is a 150-foot monopole at the site of the Riverhead Substation in the town of Southampton in the core preservation area. The resolution explains when the commission sought information on this project, and PSEG Long Island forwarded their seeker determination and negative declaration that they prepared for this project. The purpose of the project is to improve resiliency in the system operations during emergency events. And it's an essential element of PSCG Long Island's communication system. I just want to note that we may need to revise the resolution to indicate that the system is owned by LIPA and that PSEG operates and maintains the system as an agent for LIPA. And so the resolution may need to be revised to identify LIPA as the applicant and the owner of the system. And the other item that's in the resolution is that the PSEG Long Island and by way of LIPA LIPA has agreed through PSEG to allow no private carriers on this monopole. So they'll be not only on the monopole, but on the whole project site. And we believe that they have agreed to that. Their attorney is on the meeting today, but this resolution is for your consideration. So is there
Well,
any comments?
could I ask Supervisor Schneiderman a question? Jay, is there a height limit on poles in your town that they would have to seek a variance from?
You know, I'm gonna let Janice answer this. She wrote the master plan for these types of structures. So if Janice, you might have to be unmuted. There is a height, yes.
And Polly, can we also unmute Cy Gruza, whose name I saw and face I saw 2 minutes ago? He's the attorney for PSE&G. Thank you.
We have Janice. Janice, are you there? I don't see her as muted.
No.
Jay, just a quick question as a utility. They would still have to seek a variance for building a pole beyond the height limit allowed by the town. Is that not correct?
I believe that's correct, though PS LIPA will claim an exemption from local zoning.
I have to say, as Supervisor Brookhaven, I recognize no such exemption.
Yeah.
Particularly LIPA,
I don't either. I'm just
particularly after what they did in Eastport,
that will be
you're aware of.
that will be their position for certain, though.
That's why we have thoughts.
I agree with you.
Hi, can you hear me?
There
I'm
we
so sorry. My Wi-Fi froze right at the critical moment. We do have a height limitation. The issue and size on this call is that and you probably discussed this, is that they're claiming exemption from all local zoning. So
Really?
that is an issue for us. And they're planning another one in Hampton Bays as well, at 180 foot with another 15-foot high antenna on top. So we do have, generally an issue with anyone constructing towers without town approvals. Emergency towers are permitted, but to only a certain height. So this does exceed that, but they have submitted their claim that they're exempt from local zoning.
And I assume that is based on state law. And they've cited the statute.
Yes, and I guess according to their authority, but Cy could probably speak to that better than me.
Okay.
And Ed, that legislation that went through, that Assemblyman Thiel sponsored, was pertained to transmission lines, which this is not part of a transmission structure.
No, I know that. I'm just remembering all their other violations.
Right. And I'll leave it. There is also, now PS Public Service Commission oversight as well, but I don't know of LIPA, but I don't know that this falls into that either.
I don't know how much oversight is with the Public Service Commission, since they are a public and not a private utility. Their rates are only reviewed tangentially, and their actions are not reviewed at all. So I don't know if the Public Service Commission would take a look to determine whether this tall pole, they should have come to the town of Southampton and asked for a variance or at least made an application. Are they required to submit a site plan to the town on this?
Normally, yes, although they are claiming exemption in its entirety from all local zoning.
I gotta tell you, as a supervisor, I'm very concerned about that because then they can build whatever buildings they want. They don't have to listen to Pine Barrens Commission. They don't have to file site plans. They don't have to do anything if that exemption is in fact an exemption that has some force of law.
I agree with you.
Supervisor, just one point of clarification. To the extent an exemption exists, it's at the local level. It does not exist at the commission level. So they're not exempt from commission review. And what we're seeing is they came to us on their substation application and we granted them approval. And they came to us after they built this monopole. And now
After they built it, after the fact.
after they built it, but they're also saying we're subject to your jurisdiction and they're putting a covenant on the site that won't allow any telecommunications facilities there. So there is, to the extent they have an argument about local zoning, that's outside this commission's purview.
Right.
We have jurisdiction over LIPA and PSCG as our agent.
So if there's a no vote today, they'll take down the pole and start the process from the get-go. Is that correct?
That's why Cy was unmuted.
All right.
Mr. Gruza, how are you?
Well, thank you.
Good, welcome.
So the local law exemption is in the express text of the LIPA enabling statute. There was litigation between LIPA and East Hampton a couple of years ago, and the Supreme Court decision affirmed that there was indeed exemption from local law. That decision was vacated by the appellate division on other grounds having nothing to do with the substance of the determination, had to do with whether the case should have been treated as moot at the time it was decided. As John indicated, it's only an exemption from local law. The Pine Barrens Commission is considered a state level entity, and so there's no claim by LIPA for any exemption from commission authority.
Can I ask you a question then?
Sure.
Why did they build the pole before they came to the commission and only came to the commission after the fact?
Yeah, so this project, the project is about 200 switches that have been installed all over Long Island on the distribution lines. And this project is to allow remote control of those switches during storm events so that we can have the most expeditious and efficient flow of electricity. And so you have there 19 locations, which have the pole and the antenna, and that's its purpose, to control these switches. This is a FEMA project, FEMA funded. As a result, this was not a PSCG or LIPA capital project. It was not run by the licensing and permitting people who usually do that. It was done by a FEMA consultant, and quite frankly, they just simply missed the issue that the Riverhead substation is within the area of the Pine Barrens. There was no intention to avoid Pine Barrens Commission authority. It was a mistake on our part. I would also just note, so I mean, this is a pole that was installed within the substation. It's in an area that had already been disturbed. It's a gravel surface. There was no grading that was done as a result of this. There was no tree or shrub removal that was undertaken as a result of this, and which is why that, we believe and hope that the commission will agree that this putting in the pole was not development as defined by the Pine Barrens legislation and regulations.
So let me understand, what you're contending is that the pole does not meet the standard of development as described in the Pine Barrens Act. Is that what you're?
Well,
I would disagree with that.
sorry, that's not true.
Well, there's an exemption.
But you've made an application and you've asked for a resolution for a Nook Pro to consider this on a basis as if the pole was part of your original proposal, which would mean by definition it is development. And that's where we are today.
So is this development or is this not development?
That wasn't, we didn't.
Yeah.
that wasn't anything that we agreed to or that we said.
You just said it wasn't development. That's why I'm raising that.
Yeah.
Is that the contention of
contention
that this is not development?
The contention is that it is there's an exemption to the definition of development. It's Roman numeral 6 VI, work by utility performed for the purpose of public health, safety, or welfare consistent with the goals and objectives of this title. And this was our position, and that it wouldn't have required wouldn't have triggered any of the requirements because it would fit in that. The staff has, made its recommendation to treat it, in the manner that they have proposed, and we are, willing to proceed on that line.
Well,
folks, if I can just
I just want to clarify, and then one, does your client consider this development? And two, the final analysis, did your client not come to the Pine Barrens because it considers itself exempt?
No, we do not consider ourselves exempt.
You just read something that said you were exempt. So, you're confusing. I'm not a lawyer, but I listened to what you have to say, sir. And you just read it from a section that said that, in fact, you are exempt.
I'm supervisor and I'm not answering science questions, but there's two things going on, right? So there's an exemption that LIPA may assert at the municipal level.
Yes.
Right. So, and that's what Janice and Supervisor Schneiderman and yourself have been talking about. There's been a concession by the attorney for PSE&G that PSE&G and its agent, as agent for LIPA, is not exempt from the Pine Barrens Commission, right? So then the second question then becomes, is the activity they're proposing development, which is we have this conversation all the time about many activities. So if they are not exempt, but they're not involved in development, they don't need approval of the commission because while they're subject to our jurisdiction, their activity isn't subject to the jurisdiction. In this case, we have said that A, LIPA is subject to commission, B, LIPA's activity is subject to the commission. Therefore, we have a draft resolution that allows the activity to proceed as if they applied for it. And then as part of that approval for the monopole would be the condition that they can't add any telecommunication facility on the property, which they may argue one day was, non-development for some other reason. But if it's a covenant, they can't do it because it runs with the land. So, there's a bunch of stuff going on, but let's focus on their concession that they're subject to commission jurisdiction. And then we'd have to parse out this activity's development, this one isn't in each instance. In this case, they've made the concession that by saying we'll accept this resolution, that it was development, and they've asked for approval as if it occurred when the original substation was approved, all those many years ago. So all of your arguments are correct, and, and you should, they're preserved for the town, but we don't have to make those arguments because there's no argument, they're not maintaining, they're not subject to our review.
Folks, I'd just like to point out, we're a little bit past 3 o'clock. We do have the Dell Esperanza hearing. So, I'd just like to, do we want to wrap this up now or,
Yes.
or start the hearing and come back to this later on?
I think we could probably wrap it up, John.
Okay.
So I think there was Julie, there was a motion, a resolution was drafted and shared.
Yes.
With the commission members.
Yes, and it is not giving a determination that it's non-development. It's not making that determination at all. It's just approving the monopole nunc-pro-tunc as if it was part of the subdivision, the substation proposal. And it places that covenant and restriction, which we will need a draft to be approved and then recorded. So this is not saying it's non-development. If anything, it is saying that it is development, and the applicant is, by you passing it, the applicant will consent, at least for now, that it is development, and this is what they agree to. And what happens in the future, we'll have to see how other structures get developed. There isn't another one, as far as I understand, in Shoreham in the core. So we will see how those proceed as well.
I just want to reiterate.
It would be difficult for LIPA to say, this one was development and that one's not development. Size good, but.
And I just
want to ensure them very carefully. It's in Brookhaven.
I just want to reiterate that Julie also identified verbally 2 amendments that should be included in a motion to adopt. That was, the first was to identify LIPA as the owner and applicant, and that LIPA would provide a covenant of the entire property, not to allow private carriers. I believe that pertains to telecommunications.
John, that's already in the resolution.
Yeah, that's in there.
Oh, it's in there. Okay, I'm
Yeah,
sorry.
Yeah,
Okay.
so we'll just identify this correctly, that LIPA is the owner and the applicant. That's correct.
Okay. All right. So is there a motion?
Dale?
So, obviously I would have, preferred they had come to us first. It's been somewhat explained, not entirely satisfactory how the error occurred. But I do think we have to treat this as if it's before us now, which it is. And I think with the added language that they can't put cellular structures, we have to look at it as part of the substation infrastructure. It is an evolving technology and things are being automated. I don't want my vote to influence how the town approaches this, because we are a completely separate regulatory authority, and we may assert our jurisdiction over this, and it may not conform. So it puts me in a somewhat complicated position, but I do think that this is development. I think we're interpreting it correctly, and it needs the waiver that we gave them last time, and doing it this way, I think is the right approach, to look at it as if it was part of the original application. So, I'll support it. I don't know that I want to make the motion. Maybe somebody else could make the motion on it.
Motion was made by Dorian Dell for the county.
Okay.
Supervisor Schneiderman, if you wish to abstain, as long as the other 2 members vote to support the motion, it can pass. We need 3 members to pass a resolution.
Okay. Is there a second?
Riverhead will second the motion.
Okay, thank you. On the motion, all those in favor?
All right.
Brookhaven?
I'm abstaining on this resolution.
Abstaining. So
my vote is necessary. I'll support it.
okay, so we have 3 votes in support of adopting the memo. The Suffolk County, Town of Riverhead, Town of Southampton, and Brookhaven Town abstained. So the motion passes with 3 ayes and 1 abstention.
I would have preferred to abstain, but I don't think the right thing to do is to kill the project either. So.
Okay, thank you. So with that, folks, we are now a little bit past due on our public hearing. Is our stenographer available and ready?
Yes, they are there.
Okay,
Dominica.
thank you.
Dominica? Yeah.
Okay, I'm ready.
All right, thank you. Okay, I will, and is the applicant here as well?
Is it Ann Anthony?
I believe
Dell Esperanza's? Okay.
they are on the phone, I think.
Yes, Vincent is on, and I just attempted to unmute him.
Okay,
I think
great,
when
thank
you're
you.
on the phone, try *6. We'll unmute you on Zoom, I believe.
There you go.
Yeah.
All right, so I'm going to read for the record. Again, my name is John Pavasic, Executive Director. I'm going to read the notice of public hearing pursuant to the New York State Environmental Conservation Law, Article 57, Section 012110, and the Central Pine Barrens Comprehensive Land Use Plan. Notice is hereby given that the Central Pine Barrens Joint Planning and Policy Commission will hold a public hearing on Wednesday, January 20th, 2021, on the matter of a core preservation area extraordinary hardship waiver. The name of the project is the Vincent Dell Esperanza Core Preservation Area Hardship Waiver Application. The owner applicant are Vincent and Gina Dell Esperanza. The project site location is 102 Topping Drive, Northampton, Town of Southampton. The Suffolk County tax map number is 900-164-4-40. The project description: the proposal is a 2-lot subdivision of a 1.85 acre parcel in the 15 zoning district. Lot 1 is 21,663 square feet. Lot 2 is 58,918 square feet and contains an existing residence. The area outside of the existing residence is naturally vegetated. The hearing will be held remotely at 3 p.m. on Wednesday, January 20th, 2021 via Zoom format. The Zoom meeting link will be provided on the Commission's website along with project materials at https://pb.state.ny.us. And for the record, just would like ask the Commission members to identify themselves for the record, starting with Suffolk County.
Dorian Dale, representing the Suffolk County Executive.
For the town of Brookhaven.
Ed Romaine, Brookhaven Town Supervisor.
The town of Riverhead. Town of Riverhead. It's town of Riverhead, and we'll come back to them. Town of Southampton.
Southampton Town Supervisor Jay Schneiderman.
Thank you. Is the town of Riverhead present?
They're on the call. They're not unmuting and their video is not on.
Okay. I believe we had Dan McCormick representing Riverhead Supervisor Aguirre. Okay, so why don't we turn to Julie Hargrave to present this application?
Thank you. Good afternoon. I will briefly go over the staff report that was sent in the e-packet, and the applicant is on the call if you have questions of them and if they need to make any presentation to you. So just to go over the timeline, the deadline for this application to be decided is next month, February 22nd, and now the meeting is February 24th, so we will need an extension from the applicant to at least through your February meeting, if not the March meeting, which is March 17th, for the commission to decide this application. This again is a 1.8 acre site in the R15 zoning district. And so they have plenty of area. They have an oversized lot in a zoning district of moderately high density. There is one existing residence on the property and the rest of the area is wooded. You may have seen that in the aerial for the in the staff report. This is again a 2-lot subdivision. One lot is 21,663 square feet. The second lot is the one that would contain the existing residence, and that's 58,900 square feet. There's a subdivision map in the package, and The applicant purchased this property last year, I'm sorry, in 2019. And they have explained they made this purchase to build a house, subdivide the property and build a residence to be next to their daughter who lives in the existing residence. This is on the northeast side of Wildwood Lake in the town of Southampton. And this area of Wildwood Lake is a developed community. There are not many undeveloped lots left that are not protected. This site is adjacent to the Sarnoff Preserve to the east. And there is in the staff report, there's information on the species that the Natural Heritage Program identified as being in the area. A lot of them are historical records of plants, and mostly they are wetland plants. There is information in the staff report pertaining to the, again, this is in the hydrogeologic zone 3, and that requires a minimum of 40,000 square feet for each lot, and that is an issue for this application. I'll explain that in a moment. In the study area, again, just to go over that, if you see in the staff report, there is a map of the study area. And on the east side, again, is the Sarnoff Preserve owned by New York State, which is 1,200 acres. The dominant land use category in the study area is public land that comprises about 580 acres. And the remaining area is composed of single family residential lots on lots that are approximately a quarter of an acre. Those are around Wildwood Lake on the sort of northeast side of Wildwood Lake and the south side. And Wildwood Lake is described in the Pine Barrens Land Use Plan Volume 2 as a scenic resource. And the Riverhead Merches Road, County Road 63 north on from 51 is also described as a scenic resource. And Riverhead, this area is also described in an area called Riverhead Hills that is a scenic resource, and as well as Wildwood Lake south of Riverhead Hamlet. And those descriptions are in the staff report. This again is in the R15 zoning district, and other districts in the area include R10 and the 5-acre zoning district CR200. So back to the water resources issue. The health department we've corresponded with them to find out if this would achieve health department standards to be approved. And they have explained that, and what we've learned is that there was a subdivision in 1982 called the Woodhull subdivision that created this property. And there is a map, I believe, in the package. That created this lot and the lot to the north. And that was approved by the town, again, in 1982. And that subdivision, however, was never approved by the county health department. So there is no permit for the sanitary system for the existing residents. And to go forward with this subdivision, they really need 120,000 square feet, where they have only about 98,000 square feet. And I'm sorry, they have 80,000 square feet. They will need to make up the difference by buying some form of transfer development rights. They cannot use Pine Barrens credits because this is in the core preservation area and it's a sending area. It would be contrary to the plan to land Pine Barrens credits in the core preservation area where they are meant to be sent out of that area. So the applicant would need to purchase some form of TDR or land equivalent to about $60,000. And this has been conveyed to the applicant. They're aware of this because they would be creating 3 lots out of area that they only have enough area to satisfy health department requirements to create 2. If they had originally done a 3-lot subdivision, it may have been a different story, but as of now, they will need Board of Review approval from the Health Department to go forward with this application. So they also need to get Town of Southampton Planning Board subdivision approval, and other permits are listed in the staff report. The applicant has not applied for Pine Barrens credits. Again, this is in the core, and it's a large lot for the zoning. So based on the formula, there's an estimated letter of interpretation that the property could be eligible for 2.7 Pine Barrens credits. But again, the applicant, desires to build a subdivision and build a have a subdivision and build a residence on this property, second residence. So they are not seeking Pine Barrens credits at this time. And the items at the end of the staff report, again, they'll need to satisfy the requirements of the Health Department and the DEC Wild Scenic Recreation Rivers permit jurisdiction. You have the applicant's letter. Again, they purchased this property in 2019 to build a home to be near their daughter, and they are going through some difficulty personally in their family, and that is what they have explained in their letter. So if you have any questions for me.
Just sort of some clarifications, Julie. So there's already one house on this lot?
Yes. Yes.
And they're seeking to make one additional lot or two
Yes.
additional lots?
One additional lot. There's a net increase of one lot, one residence.
And it's entirely in the core, which would,
Yes.
so currently they would be allowed accessory types of structures, but any new residential would be a hardship, correct?
Yes. It's an increase in the intensity of use on this land. There's one residence. They would be subdividing and building one new, creating a new lot and a new residence, building a new residence.
And the current location of the house is to the south end of the property, is that correct?
Yes, it is on the south side of the property, and the whole north side is wooded. And there's slight topography on the north side as well, but no significant steep slopes. But it is the house surrounded by vegetation. Really, it's not a largely cleared lot.
And they want to create this lot for their daughter to live next to them, is that? what
Yeah,
would be-
I'm sorry, they want to live there next to her. It
Okay.
sounds like she lives in the existing residence. I think they live on the North Fork.
And Julie, just in terms of accessory structures, any sort of carriage house or accessory apartment, those are all considered development, correct? That would be subject to hardship as well?
No, not necessarily. No, I mean, we'd have to look at that more closely if that's what they proposed, if they did propose that. But accessory uses as defined by the town code are generally permitted without a hardship. They would be non-development. So maybe that is something they
To
could
do an accessory apartment, accessory structure, you wouldn't be subdividing this property. So once you subdivide it, it could be sold to anyone.
Right.
Julian, can I ask a question?
Yes.
I'm very sympathetic to the applicant, but I'd like to go back to this lot. This lot, I believe, was originally created in 1982 as a part of another subdivision that was taking place. That it is my understanding that the Department of Health Services for Suffolk County never approved. Is that correct?
Right. They never approved the subdivision that was approved by the town in 1982.
So where does that leave that legally if the town allowed the subdivision in 1982, but the health department did not recognize the subdivision?
From our understanding, the health department, if this were to go forward, they would need to legalize that issue with the health department. If it doesn't go forward, I can read to you what the health department wrote. Can I just do that? It says, The department never received any applications for the sanitary systems serving the existing structures on the property. If the proposal is to legalize the 2-lot subdivision approved by the town of Southampton back in 1982, then a board of review variance will not be required, as the original parcel had sufficient lot area, 2.63 acres, meeting the lot size requirement of Article 6 of the sanitary code. A board of review variance will be required if they're proposing a 3-lot subdivision. That is what they've said.
Thank you. Julie, it's Dan. Could I ask you a question as well?
Yes, please.
To confirm, you had indicated this was hydrogeologic zone 3 that requires a minimum of 40,000 square feet for each lot, correct?
Yes.
Do we know who owns the site directly due south of that location in the event they're going to be required to purchase property to satisfy that condition? I mean, is that feasible that they may be able to buy additional lottage or parcels in that area?
I think that's privately owned, and that would create maybe more issues with, more subdivisions. I don't know if the private owner to the south would be willing to give part of their property to be subdivided and to create larger lots for this subdivision. So the health department, I'm sorry, I'll just say the health department has said that they would need to buy land. They would look to have the applicant buy land in the same 0 to 2 year watershed of the Peconic River, since that's where the site is. So it can't be like in Manorville or in Brookhaven somewhere.
Okay, but in the absence of that condition being realized, it appears then the Suffolk County Department of Health would not approve this subdivision, correct? In terms of sanitary flow.
Well, they would need a board of review variance, and that is just something we don't have that application. I don't think they've made that application. It's discretionary perhaps, so it's not a guarantee that would be granted. We would need more information maybe from them.
Sure.
Yeah.
So the applicant obviously can flesh that out. So at least they know that's part of what we're looking at right now.
Yeah. Maybe the applicant can shed some light on if there are discussions with the health department.
Thank you, Julie.
Thank you.
Are there any other questions of commission members for Julie? Okay, hearing none, why don't we allow the applicant to be heard?
Hello?
Yes, hi, Vincent.
Hello? How you doing? Oh, okay, good. Yeah, I did.
Can you please identify yourself? And I guess, do we need to swear in, John?
Sure, go ahead. Yeah, we could do a virtual swearing.
Okay. All right, so can you please wait for our stenographer to swear you in, please?
Oh, okay.
Okay, will the applicant please raise your right hand? Do you swear that the testimony you are giving under oath is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, please go ahead.
Okay, so I saw that the house was for sale, I guess, 2 years ago, and it was listed as R15. So I had called the town at the time, to find out if I could put another house on it. And I spoke in the zoning department, and I said, I just wanted to put one house, not zone, not take the house down and put 3 houses. And they said there was no problem. So I went to the health department, after I purchased it, and they had told me that it was, the subdivision wasn't finalized for the house, in 82, that I would have to buy credits for the difference. And so then I went, everything was going good with the town. So I went to had it surveyed, And then after the survey, I put the application in with the town to have it, the subdivision. And then like a week before, that's when they told me, he called me up and said that it's in the Corps and I need to get an approval with the Corps. But I bought the house, I paid extra because, it's only a 1-bedroom house, because I thought I could build a house for myself next door. Well, that's, that was, I guess, my hardship, because it was, surprised. I thought I called the town and they said I could do it. I had no idea about it's in the, in the Corps preservation, or it wasn't a finalized subdivision. I just figured it was R15. He said it was okay, and that's why I proceeded. And that was why I'm here now.
Okay, thank you, Mr. Della Speranza. Do the commission members have any questions for Mr. Della Speranza?
Yeah, did you have a lawyer representing you when you bought the property?
Yeah, I did. But
yeah, the thing is, you're dealing with two different agencies. So at the town level, if you were able to subdivide it and get a second lot, you still would need to come before the Pine Barrens Commission to put anything on that lot. The town has certain provisions where we allow sanitary credits and things like that to maybe satisfy the town's requirements, but the Pine Barrens Commission is a completely different set and doesn't allow Pine Barrens credits to be transferred within the Corps. So I don't know who told you that you could build a second house here, but it always would have needed to come before this body, even if they allowed it.
Well, they didn't mention it until I put the application in. After I bought it, and I put the application in, same person, and then it was like just a week before the meeting. Then he mentioned about the Corps. I had no idea about the Pine Barrens Corps.
Even if you created a second lot, you can't put a house on it without this commission. That's the problem. So
no, I understand that now, but I never even heard of the Corps. No one's mentioned.
Yeah,
I can't blame the town for not saying, listen, you got to find the Pine Barrens Corps.
Yeah, that's why I asked if you were represented by an attorney, but
yeah, no, I was, but I didn't. I'm not even sure. I didn't even mention it to him what I was doing. I was figuring. I called the town. It was R15. I called them up. They said I could subdivide it. So I was happy with that.
Yeah.
So you've made an application. Good afternoon. I'm the attorney for the commission.
Hi.
How are you? So you've made an application to the commission for approval to subdivide and build a house. And under the law, you need to get a hardship approval from the commission before you can do that. And if you can't get that approval, you can't proceed. Unless it's non-development, which you could try to look at the law and see if there's a provision that would apply. So first off, you always encourage a representation so you can understand what's going on, although I'm sure you understand what's happening. So under the law, the commission can only grant approval, which means you could build your house if you can demonstrate that there's an extraordinary hardship if you're not allowed. And the law gives the commission the tools to measure whether you have an extraordinary hardship. They give them standards that they have to apply, and they apply them after you show why this hardship exists. And those criteria are in our law. I'm sure Julie sent them to you as part of the materials you had from the commission staff, and if you haven't, they're on our website. So you need to go through those today and say, this is why my hardship exists. If you don't do that, or if it's not sufficient and the commission determines there's not a hardship, you can't get approved. So are you prepared to make that showing, we call it a showing, to put into the record, which means you tell us what happened and our stenographer writes it down, that becomes a record on why it's a hardship under the criteria in the law, 50, environmental conservation law, section 57, article 57, section 121, to be specific, how this hardship exists. Otherwise, there's no ability for the commission to measure whether you've established a hardship. And if they can't measure it, they can't approve it.
Okay. So is a hardship like money?
No.
Okay, because that's the hardship.
But you may want to, you may want to read the law. I apologize, my light turns off if I don't move out of my chair. You may want to read the law and go through the elements and then provide the rationale. And if you can't, then we can proceed as well. Okay. That's where we're at today, just to set the stage.
John,
Okay.
John, can I ask you one question, sort of a follow-up on my earlier line of thought?
Of course you can, but I always, with questions from Supervisor Schneiderman, I always like to say, we may want to go to executive session because you usually ask me, what should we do? Or, interpretation of the law. With that caveat, let's go.
You obviously, you've made the case that the hardship has to be explained. But we as commissioners also have to look at whether it can be achieved without the need of a hardship. If there's another way, if the stated goal is for this gentleman to be able to live on this property with his daughter, and there is a way to do that does not require a hardship, that in a way says, you can't really make an argument for a hardship if there's another way to achieve it. So can you, John, are you allowed to expand an existing house, create an accessory apartment, or is that something that is not considered development or does not require a hardship?
And as just a general observation with your questions, Jay, I hate the hypotheticals because here we go. But the expansion of a house in the core is typically non-development because there's a provisional law that says customary accessory uses, and that would be an expansion. Having said that, if there's a proposal to expand a house to build like a mother, daughter, father, son type of scenario, they should come back to the commission and say, does this constitute development? And then we can look at a specific plan rather than a hypothetical plan.
Right. So rather than an extra bedroom, a room with a separate entrance, you're saying we'd have to.
I don't know what it would look like. So when I can't figure out what it looks like, I can't say yes or no, or I can't provide counsel on whether it's yes or no.
Okay.
It doesn't matter what I say. It's what you ultimately decide.
No, understood.
But what I will observe, he's not said anything today, and Mr. Dell Esperanza is and I apologize for using the he hasn't. Mr. Dell Esperanza has not stated any grounds for a hardship yet.
No, he's only stated the reasons why he's here, but not the hardship.
Yeah, that's right. So what you can all do, so here we are. So we can either close the hearing, and at that point the hearing's closed, and there's, the record is what it is, and then you'd have to deliberate on the record. We could see if the applicant wishes to ask for an extension, where we would perhaps close the hearing with an opportunity to reopen it when he has or she has gone through and made sort of a little bit more of research and maybe a different argument. Or if we wish, we could just say we're going to continue this hearing next month, which forces him and her and whomever to come back with a ripe application. Right now, it's really not ripe because they haven't said anything, except for the town told me it was okay. And we know mistake or ignorance is in a justification for an approval.
I was wondering the same thing as my esteemed colleague, the supervisor from Southampton, and I find that this whole issue, frankly, begs a lot of questions, which I'm not going to belabor you with, but there just seem to be so many elements that, frankly, are not really forthrightly addressed, and it does engender a certain amount of suspicion, I must say.
So we need a motion at this point.
Oh, wait, folks, it is a public hearing, so we need to open it up to the public if there's any comments. So We did do advertise, so Polly, are you ready to do so? At this point, we have not, no one pre-registered to speak. So at this point, I guess we could poll the folks, folks who are participating via the Zoom application. Polly, would they either use the raise their hand feature or the chat to indicate if they want to speak?
Yes, that would be very helpful.
All right, so folks who are participating via Zoom on your computer or other electronic device, at the bottom, you'll see there's a chat emblem as well as a raise hand emblem. If you wish to speak in regard to this application, please let us know via one of those two items. If no one participates via that, then the last thing we will do is then go through those folks who are participating by telephone only and poll them one by one to see if they have any comments. So I'm not seeing anyone at this point indicating either via chat or the raise their hand function that they wish to participate. Do we want to go through the folks that are participating by phone?
So we don't have anyone that's calling in from phone. Everyone who has joined us was through the Zoom app, with the exception of Mr. Dell Esperanza.
Okay. All right. So it looks like, folks, we have no public comments being offered here. So, John, I guess we would be back on the commission determining how to proceed at this point.
Yep. Yes.
So my thinking at this point is to close the hearing and make a decision on what we have. I don't think Mr. Dell Esperanza is going to be happy with that decision, but he can always reapply for different relief. But, you know, the request was made for the hardship exemption, and it's an active application. We've held a public hearing, and I'm okay with closing it. If other people feel they want to leave it open to give the applicant a chance to modify the proposal or provide additional information, because no information was provided today, that's okay too. But
Do the commission members, if they close the hearing, want to leave it open for a 10-day comment period?
Can you?
Question? I'm sorry, John, can I ask a question?
Yes, please.
John Malazzo had laid out 3 very cogent suggestions to the applicant. And in relation to the other constructive comments made by the other commissioners, perhaps at this juncture, the applicant can guide us on what the applicant would like to do, given the information they now have at hand.
Well, I'll review the laws, and I'll see if there's a hardship. I'll look the paperwork over. I thought that I had a hardship with, buying the house for a little more than, it was worth, because I thought I was getting a piece of land with it. But I'll look the paperwork over, and maybe we can have another meeting.
all right, then I'll make a motion to hold the hearing open then.
Okay.
You're gonna have to give me somebody has to tell me the next date.
Well, Mr. Dell Esperanza, are you consenting to extend the hearing to the next commission meeting date of February 17th?
But 24th,
February 24th.
24th, I'm sorry.
right.
24th.
And then we need an extension of the deadline too. So maybe until March, at least March 17th, if possible.
Mr. Dell Esperanza, are you offering to extend the decision deadline to the March date?
Yes.
Okay.
Sure.
March 17th, I think it was. Okay, so I'll make a motion then to keep the hearing open till, what is it, February 24th was the date?
Correct.
Yes.
Just for a point of clarity, are we keeping the hearing open in that he's allowed to supply a written comment? Or are we going to come back and have a public hearing like we're having now?
No, keeping the public hearing open. It was
Okay,
just
so we're gonna reconvene with the stenographer next month. Okay,
Yeah,
fair enough.
sort of recessing or adjourning the hearing till that day.
Okay. Yep.
Okay, is
There'll be
there a,
motion to adjourn and accept the extension until March 17th.
Yeah, thank you,
Made
John.
by Supervisor Schneiderman.
is there a second?
Second, Riverhead.
Second by the town of Riverhead. All in favor?
Aye.
Aye.
Any opposed? Any abstentions? The motion carries unanimously. Okay, we are extended. Thank you.
Okay, thank you.
Thank you. You're done. We wish you well.
Have a good night. Good day.
Thank you. Good, and
Okay, bye.
Hi. Madam Stenographer, you are completed. Thank you.
Okay, thank you.
See you next time.
Yep.
By Zoom.
Okay, thanks, folks. So we are now back on the regular agenda. We are now at item 3B, Quogue Wildlife Refuge Request for Determination of Jurisdiction, 3 Old Country Road, Quogue. Ms. Hargrave.
Okay, thank you. You should have received in the package a letter from Quogue Wildlife Refuge, a more recent letter than their December submission. It's dated January 7th. And that explains in more detail, as requested by the commission at your last meeting, their plans for the expansion of the nature center, and the purpose of the expansion for more program space and exhibit space and meeting space, meeting with scouting groups and meeting by staff. They currently use their kitchen as a meeting area, and they have expressed that they need this space. That is for the expansion, and it almost doubles the size of the nature center, which is about 3,000 square feet right now. And with the expansion, it would be around 6,000 square feet, first and second floors. So they have explained in more detail their purpose for the expansion. And this item is also on to revisit the proposed construction of a maintenance barn that's 2,700 square feet. Both the expansion and a barn of that size, they appear to be consistent with the development provisions and would require a hardship. So that is what we have before you today. Do you have any questions on this based on the information that they have submitted, or the applicant is on the phone as well, I believe, or available by Zoom to address you if you have questions.
Well, just clarification again. So the storage building, that would need a hardship?
Yeah, this is not a residential property. This is a non-residential property. Okay. And the barn is for equipment, storage and workspace. And again, as a non-residential use, this appears to be development, but what?
It's something that probably we talk about in a closed session. And then after that closed session, we can come back and perhaps have further information for all that are participating today.
Even for the expansion of the nature center?
Yeah, I think that it's all tied into issues that are worthy of having some privileged communication.
Okay, so folks, we'll when we get through the rest of the agenda, we'll go into executive session and then come back out to discuss and present any further deliberations by the commission on that matter. So why don't we jump to item 3C, Harriet Murphy, Letter of Interpretation Credit Appeal. Julie or Jerry?
This is just on to schedule a hearing for next month, February 24th. I'm not sure if Jerry is He's on, but okay, there he is.
I'll make a motion to schedule a hearing on this matter for February 24th.
I'll second.
All in favor?
Aye.
Any opposed? Any abstention? Motion carries unanimously. Thank you. All right, so we are now at 3D, compatible growth area, core preservation area, and critical resource area. This is the Lewis Road plan development, residential development assertion of jurisdiction application in East Quogue, which entails development of a seasonal resort community, 118 single family and 12 year-round workforce housing units, 18-hole golf course, a sewage treatment plant, recreational uses, ponds, roads, infrastructure on 608.45 acres on 178 tax parcels, and the decision deadline on this is due today. A draft resolution, which also contains secret findings, was provided to the commission for its consideration.
I'm sorry, John. I'm sorry. I don't mean to interrupt. Is it possible for us to have a 5-minute break? The supervisor is wrapping up the town board meeting. She'll be in 5 minutes.
The rest of the commission members, are you comfortable with taking a 5-minute recess?
That's fine.
Okay, so we'll take a 5-minute recess. We're still in public session. So 5 minutes, it is on my watch, it's 10 to 4. So at 5 minutes before.
Excuse me, John. The Quogue Wildlife Refuge had provided an inquiry if they could speak on the proposed expansion of the Nature Center.
That's fine with me.
Yeah, 5 minutes.
Well, in 5 minutes, then we'll go back to that. So if they can hang tight for 5 minutes.
No, I think, John, you could probably have them give their talk now, and then
Right now?
5 minutes will
Okay.
allow the supervisor to come in. I think she wanted to be part of the Lewis Road.
Yes.
Okay.
Thank you.
deliberation.
All right, so we'll just remain in session. Okay, so why don't we, if we can give them the, unmute the mic. Okay, please identify yourself again.
This is Michael Nelson, the Executive Director of the Quogue Wildlife Refuge.
Okay, go ahead, please.
I just wanted to speak in regards to the addition of the Quogue Wildlife Refuge. I know Julie had mentioned the space, the total square footage would be about 2,700 square feet. The first floor expansion where we're looking for is actually only 960 square feet. And we're also proposing to use the current and the addition attic space as storage and usable storage space. Right now we have a pull down staircase that we access our attic for storage space. So that's where the total usable space would come into 2,700 square feet, but the actual public and space of the Nature Center would only increase by about 960 square feet.
Can I just clarify two things? There's two projects here, okay? There's a maintenance barn that is 2,700 square feet. And then there's an expansion of the Nature Center. It's a separate structure that in the applicant's email, December 3rd, they said the Nature Center total proposed square footage, first and second floor, would be 66,410 square feet. And the total existing first floor square footage is 3,050. So that's where the proposed expansion net increase is approximately 3,000 square feet. Is that not correct?
I guess it would all depend on what if you consider the attic space, the current attic space, square footage of our Nature Center building. Right now, apparently, I guess the Nature Center building is about 3,000 square feet. On the first floor, we have a pull down stairs to the attic, which is probably about 1,500 square feet of of attic space, which is only accessible by a rickety pull-down staircase. So we're looking to causing the least amount of destruction and construction and damage to the surrounding vegetation is to expand about 960 square feet off the south side of the Nature Center building, and then also to create additional attic space above that extension, increasing the attic space to, which would be, I guess, about, the attic space itself would be about over 2,000 square feet, which would be used for storage, mainly for storage, but it would be accessible by a staircase, and that's where, but not open to the public. If that makes any sense. And as far as the addition of a pole barn or a Morton building, which is a separate project that we're looking to get a determination for. Currently, we have temporary structures in that area. It's an area that is already used as a maintenance area, and we have temporary they're called shelter logic tent structures that usually have I guess a 5 to 7 year lifespan, and some of them are already on their almost 20-year lifespan. And we're basically looking to consolidate those. Right now, there's 4 temporary structures up there, composing of about 1,500 square feet. Plus, we have a storage shed for the residents and a small little barn for the residents. So a total of about 2,000 square feet of maintenance storage area for the refuge. And the building that we're looking to construct, again, causing the least amount of, taking down the least amount of trees. In fact, there would only be one small oak tree that would have to be removed, would be, we're looking for about a 45 by 60 foot pole barn or Morton style building to house all of our equipment to maintain the 300 acres of the refuge property.
Are there any questions for Mr. Nelson from the commission members? Okay.
John, I'm sorry, John, Dan and Riverhead. So basically what was relayed by the applicant is consistent with what the report indicates from Julie at this point, correct?
Julie, do you have?
Yeah, well, I was going by the information they provided in their email. Yeah, the proposed maintenance storage building is 2,700 square feet. Separately, there is an expansion of the Nature Center that they have explained is 3,050 square feet. And they're looking to add 960 square feet to the first floor, making the first floor square footage 4,010 square feet. And then expanding the second floor as well, approximately 900 square feet, combined with their existing attic space. So it's more, maybe around 2,400 square feet for the second floor, if that's right. Maybe they can provide. There's no plans for this yet. This is really just been explained in a narrative and drawn on some old plans. But so it's up to the commission whether this is development or not. This is the expansion of the Nature Center. And also the building, the maintenance building.
And I stand, again, we have issues to discuss about this, so that's where we're at.
Okay.
Can I ask Michael one question before we move on? Just Michael, can you just say what percentage of your activities have to do with scouting?
Well, as far as scouting goes, there's has never been a since the early 80s, never been a year where we're not working with scouting groups. Eagle Scouts on Eagle Scout projects on the refuge, Girl Scouts for gold, silver, and bronze awards. We do over 400 programs every year. I would say at least 25% of those are involve scouting. That's just our public programming. All of our educators are merit badge certified to lead scouting groups and certify scouts for different merit badges. So
I'm not sure you're answering my question though. Because, I've been there many times, obviously, and it's a nature center.
yes,
It's not a Boy Scout or Girl Scout camp. So I think you're trying to make an argument under a scouting provision, and I'm trying to ascertain to what degree is it primarily a scouting facility or is it primarily a nature center?
we are a nature center that offers scouting opportunities and programs, and about 25% of our public programs, I would say, are involve scouts.
Okay, thank you.
All right, folks, at this point, why don't we just hold this in abeyance? As we discussed previously, we'll go into executive session at the end of the agenda and then come back out into public session. But at this point, why don't we move on to the next item, which is road, item 3D on your agenda. And the commission has before them a draft document. It's entitled Central Pine Barrens Joint Planning and Policy Commission Findings Statement and Decision for Lewis Road Planned Residential Development Subdivision Assertion of Jurisdiction Application. And it also states State Environmental Quality Review Act, January 20th, 2021, and Certificate of Findings to Approve. So last week, a week ago on the 13th, the commission deliberated in public session in regard to this application. And so the commission has before it a resolution that has two parts. A motion to accept the finding statement for the Lewis Road Planned Residential Development Assertion of Jurisdiction Project, and then a motion to approve the Lewis Road Planned Residential Development Assertion of Jurisdiction Project. So with that said, is there a motion by a member of the commission to first accept the finding statement?
I'll make a motion to accept the finding statement.
Okay, a motion by Supervisor Schneiderman. Is there a second?
I'm sorry, John, it's the motions to accept the finding statement and it's all
So
in
it's
one document.
Oh, okay. I just saw that it's okay. So just a combined, it's a combined, combined motion to accept findings and to approve the project. So
It's to, John, it's a motion to issue the finding statement and find that the project conforms with standards and guidelines as set forth in the meeting of last week with the conditional on those several that were conditioned on other approvals.
Okay.
Can I ask a question on this?
Let's just get the motion. So that motion, as I described it, is approved by, made by Supervisor Schneiderman. Now we can have discussion.
Is
You need a second first.
second first. Is there a second?
Second.
Yes, I'll second.
Seconded by Supervisor Aguirre. Okay. Discussion on the motion.
My question is, what is its relation to SEQA?
So this is to adopt a secret finding statement.
Can I ask a question then based on that? Since there was no lead agency for SEQA at all, and no coordinated review amongst the various jurisdictions, how are we empowered to do this?
Town board was the lead agency of Town of Southampton.
town board, they were the lead agency, I believe, for the Hills, which is a totally different project. And the town board eventually, as you know, Jay, voted in the opposite and are now opposing. The majority on the board currently opposes this project. I thought it was based on the planning board originally, when it was called the Hills. How did we get here for this sequel? I think that's a question worth asking.
Yeah, I believe we asserted jurisdiction based on the original proposal.
But this proposal is totally different than the original proposal.
Agreed.
And there has been no coordinated review. And my understanding is there is no lead agency for the Lewis Road project. I think you're guessing
The
a
applicant
mistake.
during the, so this came up during the hearings, and that was provided, testimony was provided during the hearings from the applicant and his, the applicant, Discovery Land Ventures, Chick Voorhees, and also their attorney. So that these issues were raised and described and addressed by them during the hearing.
Again, there is no lead agency that I'm aware of for Lewis Road. There is no coordinated review as required by SEQA. I believe by adopting these statements, this is a fatal flaw for approval for this project. And as we know, I mean, there's no one here that doesn't think that this issue is going to end with the commission's decision. This is going to be litigated. I'm raising these issues because I think there's substantial legal issues that go to the heart of this matter. There has been no coordinated review, no lead agency for us to assume and approve and adopt as part of SEQA. I just don't get it. I just don't think it's appropriate.
There's been extensive secret done on this project, both by the planning board and the town board. And if Janice wants to weigh in on this as the head of our planning division, but this is not without extensive secret.
But is it a coordinated review, Jay? What other agencies have you coordinated with?
I'll allow Janice to answer.
Well, the town board was the lead agency on the Hills application. That is absolutely.
Just let her.
And I think that the matter went then to the planning board at the preliminary plat, subdivision review. And they determined that that the lead agency still was the town board. And that they were acting as interested agency. And I believe that's still happening here. And John Malazzo may be better suited to answer this question. I also believe that this is already a subject of the litigation from the preliminary plat. That is an outstanding issue.
That's why I'm raising it, because if the town board took lead agency status, it was for the Hills. This is a totally different project in many, many ways. And I think if you went back, and I'm not that familiar with the politics of Southampton, but I think you have a majority of the board that's opposed to Lewis Road as it's currently constituted. Correct me if I'm wrong, Jay.
Well, we don't have a PDD law anymore, Ed. We eliminated the entire law. So
on what basis?
I could tell you that the board that voted on it at the time, and there were a lot of elements to this, including a lot of mitigation. It required a supermajority. It had a simple majority in support, but not a supermajority. So 2 members were opposed to it. It was a fully discretionary action. It didn't have a series of standards and guidelines like this does before the Pine Barrens Commission. So there were some members who did not feel, for their own particular reasons, that this was rezoning this property was the right thing to do, and that's why it failed. The town imposed the supermajority condition on the project, on projects like these, when they adopted the PDD law. They made it subject to a supermajority. The typical zoning would be, as you know, would be a simple majority.
And this is no longer considered a PDD?
It's no longer a PDD. Now it's considered an as-of-right subdivision.
Because the planning board made a decision that the golf course was an accessory use?
The zoning board.
Zoning Board of Appeals, yes.
Well, the planning board decided to refer it to the zoning board to clarify this issue, whether, clearly subdivisions often have shared recreational amenities. Maybe it's a baseball field, a swimming pool, tennis courts. Could a shared golf course, and we've seen shared polo fields and things like that, could a golf course be a shared recreational amenity? The zoning board said yes, as long as you have enough acres of land. Yes, that can be a shared recreational amenity. So we don't prejudice based on the type of sport. And they determined that, yes, you can do that. And so it went through a standard subdivision approval.
I just looking at the chat thing, and Wayne Braun, who is the attorney, one of the attorneys for the applicant, said it's unfortunate I haven't reviewed the record. This is not a new project. Jay, is this project different from the Hills? Is this a new project? Or is it the same project as the Hills?
Well, when we asserted jurisdiction, it was on a larger project. So it had a membership golf club that was a commercial use that would not be allowable in a residential zone. That's why it needed the zoning change. So that piece has changed. It was still an 18-hole golf course. It was still a 118 lot subdivision. But the original plan was significantly more disturbance to steep slopes and was significantly closer to the Pine Barrens core. The sewage treatment plant was significantly closer to the deeper recharge areas. So many things have changed, but all in ways that lessen the environmental impact.
I'm looking again at Mr. Wayne Braun, the attorney's, the applicant for the attorney, and he said the subdivision of the property was always part of the PDD process, and the entire project was contemplated in the PDD review. Which seems to differ from what you just said, Jay. So I'm looking at what their attorney is saying.
The PDD is a subdivision as well, but it included a membership golf club. You're probably familiar with these because we have lots of them. Shinnecock Hills, Golfit Bridge, Sabonic. Memberships in my neck of the woods could be $500,000 a membership, $1 million a membership. That the applicant gave that up, right? When they were denied the PDD, they walked away from the membership club and were left with just a subdivision and a golf course that could only be available to the residents and their guests. No private memberships. And that was a fundamental change. So yes, it's different.
My understanding of secret is that it requires strict compliance. This, Lewis Road is a new subdivision application, not a change of zone. So whatever activity the town board took on this doesn't apply. They took that activity on the Hills, not on Lewis Road. This is, in my view, a new subdivision application, not a change of zone.
That's true. It's a subdivision application and not a change of zone. It's an as of right subdivision.
But you didn't coordinate the review. You didn't take lead agency status to determine it, determination. And please, if you look at the chat, Bob from Group for the East End is raising these questions. I'm just repeating them.
Right. Well, the record is closed, I remind you. So
No. But they're raising the question, if the town board has approval authority over the Lewis Road PRD, does it?
I'm sorry, there's a town board? No, it's in front of the planning board.
Let me get the chat. The chat is here.
We have delegated that responsibility to the planning board. As you know, subdivisions. I'm sure you're very familiar. It's not in front of the town board. Zoning changes, front of the town board.
Is there any additional discussion on the motion? All right, so we have a motion and a second on the motion. All those in favor?
Aye.
Aye.
Okay, so I see it's the Suffolk County, Town of Southampton, and the Town of Riverhead in favor. Any opposed? The Town of Brookhaven is opposed. no abstentions. The motion for approval is approved by 3 votes, and there is 1 no vote.
And 1 absent.
Excuse me?
Supervisor, did you abstain or did you vote no?
No, I voted no, but there's 1 absent. I'm
Yeah.
not abstaining, I'm voting no, and there's 1 absent because the appointee of the state is missing.
Yep.
So there's 1 absent. So all of our votes, including the votes from last week, should show 3 in favor, 1 opposed, and 1 absent. Unless you change the membership of the body.
We will make those appropriate changes. Thank you. So the motion carries 3 votes in favor. All right, folks, we are at the end of the regular agenda. I'm just going to check the public comments to see if we've received anything additional. There are no additional public comments that have been received. As we had mentioned previously, there's a need to go into executive session for legal considerations. So is there a motion to go into executive session and then once we're done with that, to come out of executive session? And before we act on that, I'll just point out that the purposes of the commission members to go into executive session, please physically click on the leave the Zoom, click that leave Zoom button. What you'll need to do to come back into public session is then to reconnect to the Zoom connection. So for the rest of the folks participating in this meeting, they will still be connected to Zoom while the commission is meeting in executive session. That is the cleanest and easiest way to do this. So please make sure that when we go into executive session that you click on the leave button to leave the Zoom meeting, and then you'll have to click back on the link to return. So with that said, is there a motion to go into executive session? Then once that is complete, to come back into public session?
Motion.
Motion, I'm sorry, who was the motion? It was Mr.
Dorian Dale.
Dorian Dale. Is there a second?
Yvette Aguiar.
Okay, Supervisor Aguiar. Okay, all those in favor?
Aye.
Aye.
Any opposed? Supervisor Romaine opposed?
No, I'm in favor.
Oh, you're in favor, I'm sorry. Okay, so we have 4 in favor, none opposed, and 1 absent. That is the state. All right, so we are now in executive session. So I would ask the commission members and designated representatives, please, to physically click on the leave button, and we will meet in a separate venue. Thank you.
Did you, John, did you send the call-in link?
We'll send it again.
Yeah.
As soon as we'll send it right now. Thank
Send
you.
it right now.
Okay, thank you.
I'm not going to call in.
And particularly with the law, for residential properties, customary accessory uses are non-development, but it does not state so for commercial accessory buildings, and many of them have been subject to our review. I don't know any that have not. So it's unfortunate, but I believe we made an error in classification, which needs to be corrected, which would mean that the applicant really needs to, they can make their case as to why it should not be deemed as development, but if it is indeed development, then they would have to make their case for a hardship or possibly using the scouting provision, but they would have to make those arguments before us. So, John, how should I phrase the motion here?
So I think there's 2 things going on, right? So there's the conversation about the existing building, which they're asking for an addition. And then there is the barn, shed, maintenance building, freestanding, doesn't exist. That was deemed to, by informal consensus last meeting to be deemed non-development. So I don't think there's no debate that the addition to the existing building is development. So you can do that. as a resolution, and if it's development, they have to get a hardship. Then I think the commission should give the applicant an opportunity to address the commission next month on whether the barn that they're proposing qualifies as non-development. Give them an opportunity to make the application, because you make the argument, and then we can address that at the next month's meeting. So I think what you should do is pass a resolution on the addition to the existing building as development, and then they can come back next month and say that the barn is development or not development. They can make their arguments, and we can make a resolution on that at that time. And that would give them the ability to address the commission, given the change that's consistent with the law, in my opinion, on what's going on.
And we're not revisiting the decision on the sanitary system. That still is not development.
Yes.
All right. So, yeah, so that would be then the motion to determine that the addition to the main building is development, and defer the other decision until a later date, and allow the applicant to make their argument as to why the storage building might not be development.
All right, is there a second to that motion?
Second.
A second by Dorian Dale. All in favor? Any opposed? None opposed, and one absent, being the state. So the motion passes unanimously amongst the 4 members. John, I just sent you something. Can you just let me know? Okay.
Yeah, so whether we should, I'm sorry, let me just focus for 1 second, I'm back. So I think what should happen is the applicant should hear that this now is deemed, or it's on its path, the barn as being considered development. And if they would be advised to come back next month and make an argument if it's non-development. I also would encourage the applicant not to take any actions to undertake construction or any activity, because you're running the risk of being in violation of the Pine Barrens Act, because the commission has now put you on notice that it's likely to be development, and you have knowledge of that. So if you want to address the commission briefly today, we're not going to ask you to make your formal application. We want you to have time to prepare, to consult with whomever you need to consult with, so you can make a cogent argument, to use one of Dorian's words, next month on why it is or is not non-development. We don't want to put you on the spot and say you have, unannounced decision by the commission. You don't have time to prepare, make your argument, and if you're good, you get approval. So that's why we're going to give you plenty of time to advance arguments, prepare, review, consult with whomever you wish, and come back and give us the argument next month. But cautioned and instructed, it's likely to be development based on past history, and that activities undertaken in the interim would be considered very well be a violation of the act, which we have people that have violated the act, and they've given us, fines for doing so.
Our request was just an exploratory request to find out. That's why, when speaking with Julie, mentioning that we don't have to have plans. This is a first step in researching whether these projects can be done before we, paid for an architect, paid for planning process. So, we have no plans to move forward, until, approved or granted permission from the commission, and then obviously from, the village and town and other agencies that, require permitting process. So, so understood your, your warning, or, as far as
admonishment.
Forward.
Admonition. You say admonishment,
Yes.
or say admonition? Go ahead.
I did.
2 pages.
So if I understand correctly, then,
Incorrect.
as far as the nature center the commission is deeming that development and not considered one of the non-development exclusions from the environmental conservation law?
That is correct. So to proceed, you will need a hardship.
Hardship, okay. Similar to what was done with the deck 5 or 6 years ago? Is that?
And I'm heartened to hear that you understand on the maintenance building that it's likely to be development and you're not going to undertake any activities. We just want to make sure you had a fair opportunity to address that issue, and we're going to preserve that for you and allow you to do that the next meeting. And we'll put it as a courtesy. We'll also put it up higher in the agenda so that you're not dealing with it at 5 o'clock, just because it's sort of a weird carryover.
Okay, and as far as the maintenance building, so you're asking to submit a separate letter just in regards to that building?
The commission is giving you the opportunity to provide whatever information you would like to, if you want to make an argument that it's non-development, we're encouraging you to make that argument however you wish is appropriate. If you don't want to make the argument and you concede it's development, just let us know at the next meeting and we'll proceed. What we would do is then we would just lump all of your activities into one application and hear them out all at the same time. That's like, without prejudging it, that would be the best thing. But we wanted to give you the opportunity to make an argument because last month you heard it was non-development. This is a significant change. And we want to make sure that you had the chance to make an argument to make sure we're getting this right.
Okay. Thank you.
I appreciate your cooperation.
Not a problem. Thank you.
All right, I think we have, thank you, folks. I think we have reached the end of our agenda. And so in closing, just before we adjourn, I just would like to again state that I feel it's been an honor and a privilege to have served as executive director for the last 10 and a half years. And again, I greatly appreciate your support, faith, and trust in me. And I will greatly miss you in this position. Thank you for allowing me to have a wonderful, fulfilling experience. So thank you very much. And with that said, is there a motion to adjourn?
Motion.
Okay, motion. Is there a second?
I'll second.
Second. All in favor?
Aye.
Aye. And
Any
John,
opposed?
I just want to wish you the very best as well. Thank you for your many years of public service. I've known you in multiple capacities, but I always enjoy working with you. And, you've done a great job here with the staff and, furthering the mission of the Pine Barrens Commission. And thank you for that.
All right. Thank you very much. I really appreciate that, Supervisor Schneiderman. Thank you greatly.
John, thank you for your dedication to our environment and best of luck.
Thank you. Thank you so much, Supervisor Aguiar.
But you're not out of the woods yet, John. We're roasting you next week. So just
That's true. So I heard. All right. Thank you very much, folks. And have a good night and a good evening, safe home. And so the meeting is adjourned. Thank you.
Thank you.